David.
Mr. Chief Justice, honorable justices, good day. This appeal is about stare decisis. Public Interest Litigation Institute makes no submission as to whether highway properties should be revisited. Our submissions focus on considerations on stare decisis to assist you in that deliberation. The first thing is that highway properties was decided in 1971, and it itself overruled a precedent from this court in 1955, Attorney General of Saskatchewan versus Whiteshore Salt and Chemical. It also overruled the governing authority in Ontario at the time, Goldhar versus Universal Sections and Moldings from 1963. We make three submissions as well. First, the revisitation of common law precedents is a natural and healthy process ensuring the vitality of this court's jurisprudence. Revisiting precedent ensures that the restrictions of the past are not used to separate the legal system from today's realities. It also ensures that precedent has not been undermined by subsequent legal developments, including Basin, CM Callow, and Waystec. As well, stability in the law does not preclude departing from precedent whose application leads to unjust or unacceptable results. Our second submission is that this court's power to overrule its own precedents is broader than the authority conferred to lower courts to depart from its precedents under vertical stare decisis. The two must not be conflated. Lower courts can only depart from this court's precedents under the two exceptions set out in Bedford. Departure is only justified based on subsequent legal developments or shifts in the factual matrix that fundamentally change the parameters of the debate. By contrast, this court may overrule or otherwise depart from its own precedents in the face of compelling reasons. This has been the standard since the 1967 precedent in R versus Binus.
That's a very workable yardstick, compelling reasons. How do we give that effect? Is it, does it vary with the length of the Chancellor's foot?
Definitely not, Justice Rowe. There is an overlap between these two axes, so the two Bedford exceptions are examples of compelling reasons the court may invoke to depart from its own precedents, but the court's authority is not so limited. The court has also overruled precedents that lead to unjust results. I refer to Michel versus Graydon for that reference, as well as Vavilov, paragraph 19. Our third submission, and responding more to the question, is that the joint concurring reasons in R.V. Kirkpatrick do not displace the compelling reasons standard this court applies to depart from precedent. A statement to this effect will ensure clarity in the law. Kirkpatrick states that this court can only overrule one of its own precedents if it was rendered parent curiam is unworkable or has had its foundation eroded by significant social or legal change. This represents a spectacular unilateral truncation of the court's powers in horizontal stare decisis. Indeed, these three grounds are examples of compelling reasons the court has previously invoked to depart from precedent. They do not, however, exhaust the reservoir of compelling reasons appearing in this honorable court's jurisprudence since 1967. Kirkpatrick therefore departs from the compelling reasons standard this court has applied since 1967. As well, Justice Rowe, the standard of compelling reasons was inspired by the UK House of Lords' famous practice statement of 1966, which was later adopted across the Commonwealth, including Australia, New Zealand, United States, who is not part of the Commonwealth. Incidentally, Kirkpatrick did not show the compelling reasons standard met any of the three grounds it identifies to depart from precedent. This court should therefore confirm that Kirkpatrick does not govern horizontal stare decisis. The standard remains that of compelling reasons. Our fourth submission is that the exceptions to vertical stare decisis set out in Bedford apply to constitutional, statutory, and common law precedents. Lower courts' judgments questioning whether Bedford applies to common law precedents should be set aside. Bedford's discussion of stare decisis emphasizes that it is, quote, the foundational principle upon which the common law relies, end quote. Nothing in Bedford or judgments after it suggests that the exceptions are limited to constitutional precedents, and there is no principled doctrinal reason for such a limit.
The only thing I can indicate to you is that Professor Leanna Katz of the faculty of Dalhousie University and some other guy wrote an article, a learned article a little while ago, that said that stare decisis takes on a different character depending on whether you're dealing with a constitutional question, statutory interpretation, or common law. You're saying, doesn't matter.
I certainly do not take that proposition, for in my own book, Stare Decisis, the Charter and the Rule of Law in the Supreme Court of Canada, I do say that the standard should be the same because the style and method of constitutional adjudication, including under the Charter, essentially interpolates or incorporates the common law method of adjudication of incrementalism, upon which precedents can be overruled based on changes in facts as well as law and other compelling reasons. There is no principal doctrinal reason why the Bedford exceptions should not apply to common law precedents. A higher standard could not apply since the common law is subordinate to the Constitution, nor could a lower standard apply, as it would erode the authority of this court's precedents and generate instability.
All right.
I'll end on this point just to say there should be one standard, that in Bedford. Thank you very much. Merci beaucoup.
Thank you. Mr. Paul Eric Deal.